A warm greeting to Mr. Long Chejo and to everyone watching this video. What would you do if you've been in my shoes? The issue Abraham faces when purchasing a Victorian-style property is whether the paintings and sculpture removed by Brenda are included in the sale. To determine this, we must understand the definition of land. According to Section 205, subsection 1 and paragraph 9 of Law of Property Act 1925, provided that land includes the physical land itself along with the buildings and fixture on it, which also known as corporeal hereditaments, and any rights over the land, also known as incorporeal hereditaments, where these rights extend to the exclusive possession of the thing which is subject of property. They are called corporeal hereditaments, a term which is used to denote both the thing itself and the right of property in the thing. And where they fall short of this, as for example, in the case of Prophets A. Prandra, they are called incorporeal hereditaments. The most contentious issue is whether the paintings and sculptures is fixture or fitting. The issue is essential as when the land is sold, the items that are part of the land, which known as fixtures, are needed to be transferred by deed under Section 52 of Law of Property Act 1925, where those are not part of the land are not required to be transferred by deed. The transfer or sale of charter may be valid even though it's verbal or merely written. However, the law of fixtures determines when an object which was formerly as a fittings has become part of land is recognized to be complex and confusing. Turning to fixture, the term fixture is used by writers with various significance, but is always applied to articles of a personal nature which has been affixed to the land. There was little or no disagreement between the parties as the ground that, when considering whether a charter had become a fixture, regard is to be had to the degree to which the charter has become annexed to the land, and the purpose of such annexation. The law was explained by Blackburn Justice in this term in Portland and Hobson, 1872. The doctrine of fixture, which Blackburn Justice began his analysis in Portland and Hobson's, that whatever is attached of and next to the land become part of it, is often expressed in the Latin words planto solo credit. This degree of annexation test is purely concerned with the manner in which the article attached to the premises. For example, does it simply rest on the floor by virtue of its own weight? Is it attached by nails, screws, or bolts, or has it been firmly built into the structure of the building? The greater the extent to which the articles are physically attached to the premises, the more likely the conclusion that the article in the question is a fixture. Applying the principle Chelsea Yacht and Boat Company Limited and Poe 2001, the court held that the attachment could be undone and the housework could be moved quite easily without injury to itself or the land. Moreover, it was not necessary to annex the housework to the land to enable it to be used as a home. So far as the degree of annexation was concerned, the various ropes and attachment could be untied and disconnected without any undue effort. It could be moved quite easily without injury to itself or the land. In a recent case of the Royal Parks Limited and Bluebirds Boats Limited 2021, the court held that the boat house was part of the land, hence it was a fixture as followed the degree of annexations had been such that the structure was permanently fixed to the land. It had not been disputed that the concrete slab and foundation could only be removed by a process of demolition, and would have resulted in substantial destruction of its component. It's very clear that Court of Appeal in Berkeley and Powlett, 1977, it involved painting in recessed paneling in two rooms, some of which were firmly fixed in the section in the paneling of a room and others that were affixed to a wall. They were therefore annexed to the land. But the majority of the Court of Appeal held that they was not fixture because this was not the object of their annexation. They were put in place on the wall to be enjoyed as a picture as well as a white marble statue of a great athlete weighing half a ton and standing on the floor was considering not to be fixture. The purpose of annexation test involves an examination of the purpose or reason for which the article was attached to the premises. The question for consideration is commonly stated to be whether the article is attached for the better enjoyment of it as a chattel, or whether it was attached in order to effect an improvement in the premises themselves. As noted by Sir Frederick Jordan in Australian Provincial Associations Company Limited and Colonial 1938, the question whether a charter has become a fixture depends upon whether it has been fixed to the land and if so, for what purpose. In the case of Leach and Taylor's 1902, tapestry near to the wall were held not to be fixture, but in Ree Valley 1908, similar objects were held to be fixture because the object or purpose of the annexation was to enhance the room. Lord Hasbury Lodge Chief in Leach and Taylor's confirmed that the key test was the purpose of annexation, and this was confirmed in Ham and Bygrave 1982, where garden ornaments that form part of the landscape display were held to be fixture, despite the fact that they rested on the ground simply by their own weights. Moving into the facts at hand, we will first look into degree of annexation. It's very clear in Berkeley and Pollard, paintings were not fixture because this was not the object of their annexation. They were put in place on the wall to be enjoyed as pictures. In the case of Ferdinand Bruce, Earl of Cardigan and Moore of 2012, the judgment by newer judge held that the frame pictures are hung on or fixed to the walls for a better enjoyment as pictures, however much they may beautify the room in which they are found, and frame oil painting in his judgment are and remain shutters, whether they be hung upon or even or screwed by mirror plates too, the paneling of a room or unpaneled room. It should be noted that the judge the comment of Stamp Lord Justice in Berkeley and Pollard to the effect that the frame pictures are hung on or fixed to the walls for their better enjoyment as a pictures. However much they might beautify the room in which they are found, they are still remain as shutters. One principle should be looked into the case of Ham and Bygrave, the degree of annexation with all the items resting by their own weight, suggesting that they were shutters. Secondly, each item was of a kind which might equally have been intended to be a permanent fixture of the garden or which might have been placed in the garden to be enjoyed as a shutters on its own merits. In the absence of other evidence, the prima facie inference that they were shutters would prevail. In the case of Associated Restaurant Limited and Warland 1988, pictures and metal sculpture used to decorate hotels, all of these were held to be shutters or trade fixtures and not integral part of the premises. Turning to the facts at hand, the paintings are easily removable, and although the sculptures are extremely heavy, their removal will not damage the property. This indicates that the paintings and sculpture merely resting on their own weight should be regarded as shutters. Additionally, the purpose of annexation must be considered. It can be argued that the Brenda's intention was to sell and Abraham's intention was to purchase a Victorian-style property, where the paintings and sculpture were integral components. Thus, these items should be regarded as fixtures. Clearly, an architectural design presupposes a plan and an intention, but when we look into the case of Hill, Viscount and Bullock, 1897, which have found a fixed object to be shutters, include display case of stuffed birds, even the purpose is for a bird gallery in a Setter Mansion house. However, when we look into Ree Valley, a portrait and a tapestry will help to be featured because of the way they were intended to become part of how the room was presented. In Dee and Court and the Gregory 1872 have been shown that where there is possibility of shutters forming part of the land of which might be called a grand architectural design. Lord Romilly had not used the term of intention, preferring instead to talk about whether the statue was strictly and properly part of the architectural design for the hall. This can be supported by using the case of Norton and Dashwood 1895, where the court considered the decoration of the room and held that the object is fixtures as the room had been designed and colored with reference of the object. Furthermore, the sculptures are extremely heavy, but it tends to increase overall aesthetics. Turning to the facts at hand, it can be reasonably presumed that Abraham's persistence in purchasing the property, despite the steep price, was influenced by its Victorian-style fixtures, as advertised by Brenda. Therefore, it can be assumed that without the painting and sculptures, the property's decoration might be significantly diminished. Intention refers to the purpose which the object serves. Blackburn Justice acknowledged one source here, the judgment of Baron Park in Hallowell and Eastwood 1851. Baron Park had borrowing the works of Amos and Barrett stated that the purpose and object for which the article had been put up, that is to say whether it was for trade, for agriculture, for ornament merely, or for the general improvement of the estate. This includes the nature of the things affixed, the situation of the party claiming the rights, the intention of the parties in making the annexation, and the injury occasional to the freehold by the removal. Looking at the scenario of circumstances in which an unattached object which might be part of the land, where Blackburn Justice had also explained the and court and Gregory by reference to the intention, but if the intention is apparent to make the articles part of the land, they do become part of the land. The purpose of the painting and sculpture to the overall of the property and intention of the parties can be clearly seen in the case of Norton and Dashwood, where the court ruled that the room is a highly ornamented chamber. The decoration of the room, including the ceiling, has been designed and colored with reference to the tapestry, which is the principal ornament. The removal of the tapestry, the greater feature of the room, would, in the language of Lord Keeper in Cave and Cave 17 and 5, leave the room mean and disfigured. This principle had been proved in the case of Kennedy and Secretary of State for Wales, 1996, where a carillon clock resting on its own weight was held to be part of the design, if it's the historic house. Abraham may face challenges or interested in understanding whether Branda's statement regarding the inclusion of the paintings and sculpture upon his immediate acceptance of the deal constitute a valid and enforceable claim to exact ownership of this item. In examining the case of Lawrence and Risdale's executrix and Heyman 1976, although the primary issues pertain to the refusal of claim for earned income relief, Wharton Justice's judgment insight in the significance of the term immediately derived. Wharton Justice noted that the shorter Oxford English Dictionary defines immediately as with no person, thing, or distance intervening in time, space, order, or succession, reinforcing the requirement for a direct and immediate connection. Supporting by another case of the Queen and the Justice of Berkshire, 1878, where the court held that the term immediately should be interpreted as promptly and expeditiously under all the circumstances of the case. Applying this to Abraham's situation, his argument that the Branda statement is enforceable may be weak. Branda specifically mentioned that the inclusion of the paintings and sculpture was contingent on sealing the deal immediately, not merely on agreeing to the deal. Given that Abraham needed time to consider the offer, there apparently to be an intervening period that prevents fulfilling the requirement of immediately as defined in the shorter Oxford English Dictionary. The time lapse undermines Abraham's claim to the ownership of the paintings and the sculpture based on Branda's statement. In conclusion, Abraham's may unable to claim the paintings and sculpture by Branda's statement. Thank you very much.